and got a woman who was a drug addict, and the trafficker basically said, I'm going to give you enough money to buy your drugs. You fill out the paperwork. The trafficker picked out 12 guns right in front of the clerk. He conversed with the clerk. It was clear he was buying the guns. The woman, though, did the paperwork, and the man walks out with the 12 guns. He was a criminal. He was a gun trafficker. He brought those guns to New Jersey, sold them to criminals, one of whom then shot these 2 police officers. Again, there was nothing New Jersey could have done to prevent this. It was irresponsible conduct by gun companies and weak gun laws in West Virginia. We brought a lawsuit on the officer's behalf. We successfully fought motions to dismiss against both the dealer and the manufacturer, and eventually got a substantial settlement for the officers, and perhaps more importantly, that dealer and a number of other dealers in West Virginia agreed to stop engaging in multiple sales. They would say that they, even though the law allowed them to sell unlimited number of guns, they were not going to do that. Maybe it was because some of them saw the light. I think a lot of it was because they saw the bottom line, that it no longer made financial sense for them to engage in these transactions, which they well knew were supplying the criminal trade, and innocent people were getting killed as a result. As long as they were paying the financial cost, it was going to encourage them to do the right thing. We also represented victims of the D.C. area sniper shootings, and this will give you another example of how criminals get guns. In that case, both of the D.C. snipers, if you'll remember, were both prohibited from buying guns. One of them had a domestic violence restraining order on him. The other was 15 years old. Well, when eventually they were arrested and the gun was traced back to a dealer, the dealer in Washington State had no record of having sold the gun. But it also turned out that that dealer had no record of over 200 guns that had left its store, and the dealer said, it's news to me. I don't know what happened to those guns. Now, anyone at ATF will tell you that when a dealer says that, they are selling guns illegally, off the books. No responsible business person would allow thousands and thousands of dollars of merchandise to leave their store, and in fact, well over 90% of gun dealers, I think closer to 99% of gun dealers, have no missing guns. It's fairly easy to prevent guns from being stolen in a store. So it's very suspicious when you have even some guns stolen. If you have 200, that is a really red flag indicator that the dealer is probably corrupt. We brought a case against the dealer and the manufacturer. And the theory against the manufacturer was that when you're using dealers to sell your product, and you know that there are some dealers out there that are corrupt, that engage in these irresponsible practices, you should require them to act responsibly, or you don't supply them. It's fairly easy to do. And if you don't do that, as in this case, it's negligent entrustment. It's negligent to entrust your products to an irresponsible seller. We won victories in court and eventually settled cases against both the dealer and the manufacturer. And again, the manufacturer agreed to reform its distribution practices. So those are tangible examples of the good litigation can do, and that criminals don't just get guns from the air, they get them from certain corrupt and irresponsible dealers and certain irresponsible practices, and some statistics to bear that out. 86% of gun dealers sell 0 crime guns. So only 14% of all the gun dealers in America sell all of the crime guns. Of that 14%, 1% of gun dealers sell about 60%, 60% of the crime guns. So that shows you that it's not that difficult to run a clean operation. 86% do it. And that there are a few really bad apples. And the Protection of Lawful Commerce and Arms Act, that I'm sure Representative Schiff will talk more about and others have touched on, protects the worst of the worst. And people have talked about negligence. Negligence is a concept that applies to all of us. You can be sued in negligence if you don't clean your front stoop of snow or ice, if reasonable care demands that you do that. And it certainly applies to selling guns. What the Protection of Lawful Commerce and Arms Act does is it protects licensed gun dealers, manufacturers, and distributors from negligence in certain cases, yet doesn't even protect the rest of us when we sell guns. If I negligently, I'm not a licensed gun dealer, by the way, in case any of you thought I might be. If I negligently sold a gun to somebody, for example, if somebody made clear that they were a member of Al-Qaeda, who, by the way, are not prohibited from buying guns. You can be too dangerous to be allowed to fly on an airplane, but in the wisdom of Congress, you're not too dangerous to buy all of the AK-47s you desire under current law. So, however, it might be negligent to sell a gun to someone who makes clear that they are a terrorist. This federal law would protect a licensed gun seller from a basic negligence claim in that case. But if I sold a gun to that same person, engaged in exactly the same conduct, since I don't have a federal firearms license, I could get sued. I could have to pay all the damages that anyone else in society would. Makes absolutely no sense. It just protects, again, this one industry and the worst of that industry. And there's no other industry in America that has that protection. And it was touched on that guns are exempt from laws in other ways, and one in particular that was noted, that guns are specifically exempt from the Consumer Product Safety Act. So the federal government has the authority to regulate product safety for every consumer product in America except for firearms. In fact, the CPSC, Consumer Product Safety Commission, can require safety devices for BB guns. If there's a feasible way to make a BB gun safer, they can recall the product. They can say you can't sell it unless you put in the safety device. If there's the exact same defect on a real gun, the federal government would have absolutely no authority to require a safety device because there is this special exemption that was written into the law by John Dingell, who was then on the board of directors of the NRA while he was serving in Congress, and when that act was passed in the 70s. And as Ms. Holtzman touched on, there are many ways in which guns could be made safer, which would prevent particularly shootings of children. And I'll give you one last example of a case that I was involved in, where sort of a classic case in which a 15-year-old boy finds his father's gun, wants to show it to his 14-year-old friend, knew enough about the gun to check to see if the magazine was loaded, saw that it was, found an empty magazine, put it in the gun, showed it to his friend, pulled the trigger, didn't realize there was a round in the chamber, and killed his 14-year-old best friend. We brought a lawsuit against the manufacturer, and in discovery, we found that for decades, there were inventors that were coming up with safety devices that would prevent exactly this sort of thing from happening. Either built-in locks in the guns, indicators that would warn someone, particularly an adolescent, that there was a round in the chamber. And they were begging gun companies to put these devices in their guns. And the gun companies just basically just put them in a shelf, in a filing cabinet, and didn't do anything about it. They didn't even consider these options. We brought a lawsuit. We actually lost the lawsuit. However, we almost won. We came close enough that it scared the gun industry enough that after the trial, a number of manufacturers began putting in these devices that they had mocked and refused to put in for many years. So that's just an example of the sort of good that litigation can do. Unfortunately, there is this federal law which limits that, and with the great work of our next speaker, hopefully that limitation will not be on the books for long. So thank you.
Good evening. I'm Congressman Adam Schiff. I'm a member of Congress from California. It's a great pleasure to be with you. And Dan, I want to thank you for inviting me and for putting together this fabulous panel. I hope I can shed a little bit of light on the nature of the gun issue in Congress and why this is proving so difficult. In some, it is just as crazy as Jonathan described. He mentioned that if you were a card-carrying member of Al-Qaeda and you went to a gun store to buy a gun, we could not prevent you from buying that gun. In fact, we had an amendment in the Judiciary Committee some years ago to do exactly that, to say that members of Al-Qaeda or terrorists on the watch list who can't fly in our planes would be precluded from buying assault weapons or other weapons. And that was voted down in the Judiciary Committee on a party line vote. It is as absurd as that. And I'll discuss a little bit about why that is the case and why this has been so difficult. At the memorial for the victims of the Newtown massacre, President Obama asked, "Are we really prepared to say that we're powerless in the face of such carnage, that the politics are too hard? Are we prepared to say that such violence visited on our children year after year after year is somehow the price of our freedom?" Well, I can certainly tell you that Americans in my district, and I think districts across the country, would answer that with a resounding no. I agree with the President's proposal on addressing gun violence, which prioritizes universal background checks, a criminal trafficking statute, reinstating and strengthening the assault weapons ban. Those are all important steps, and I hope that we can get them done this year. But they're not the whole answer, as the panel has indicated. And as I look for ways that we could do more to keep guns from ending up in criminal hands and those of the mentally ill, I started looking more closely at the Protection of Lawful Commerce and Arms Act, or as we unaffectionately refer to it, PLCAA, and the way in which this bill, in an unprecedented and unwarranted fashion, gives immunity to an industry that makes among the most dangerous products. Now, the other panelists have very ably described PLCAA, and I won't spend much time in further describing it, but I do want to highlight one aspect that I've been emphasizing to members of Congress during the debate over reforming PLCAA. When PLCAA was debated in 2004 and 2005, it was advertised as a very different bill than what it actually was. The sponsors of PLCAA described it as an effort to bar a very narrow sort of lawsuit. The first finding of that bill says that PLCAA is intended to block civil actions in state and federal court based on injuries, quote, solely caused by the criminal or unlawful misuse of firearms products. In other words, if an industry makes a lawful product like a gun, it shouldn't be held liable merely because a criminal unlawfully uses that weapon. Though no civil judgments had actually been entered against the gun seller or manufacturer based on that theory, many members of Congress found that purpose hard to argue with. Senator Larry Craig, the sponsor of the legislation, addressed the Senate and said, "This bill will not prevent a single victim from obtaining relief for wrongs done to them by anyone in the gun industry. But for many plaintiffs who simply want their day in court and who currently find the courthouse doors barred to them, the assurances of Placa's supporters do them very little good. State and federal courts have relied on Placa to dismiss, as my colleagues have pointed out, a wide variety of suits that would be viable, or would at least proceed past initial hurdles if it wasn't for Placa. These include claims based on simple negligence, on traditional product defect theories, and those based on public nuisance theories. There are lots of examples of how Placa inhibits legitimate tort claims, but one that hits very close to home for me was the way in which Placa barred a lawsuit by the victims of the Granada Hills shooting. For those of you who don't remember, in 1999, a white supremacist opened fire at a Jewish community center in Los Angeles. After strafing children and staff with 70 bullets, he fled the scene, only to shoot and kill a postal worker named Joseph Leto. The children and staff that were shot that day at the daycare center, where miraculously no one was killed, and Mr. Alito's widow, sued gun manufacturers under California law for negligence and product defect. They had mixed success in the courts, but before a final verdict could be rendered, Congress passed Placa in 2005. When the gun companies moved for dismissal based on Placa, the Ninth Circuit Court of Appeals dismissed the claims against the gun makers. Yet ironically, the suit against a foreign gun manufacturer, which was not preempted by Placa, was allowed to go forward. Lauren Lieb, whose son was shot that day, wrote to me recently to say, "We were denied our day in court." And that's exactly what happened. That's all our bill assures, and that is that victims of gun violence get a day in court, the same right we should guarantee any American. This case, of course, is not an isolated case by any means, and my colleagues have pointed out many others. Another case that hits very close to home for me was in my hometown of Burbank. A Burbank police officer named Matthew Pavelka gunned down by an assailant named Garcia. Garcia was a prior felon. Garcia could not buy a gun from a dealer because he had a felony record, so Garcia did what a lot of felons do and went to a straw purchaser who bought the gun for him. When the Pavelka family tried to bring suit in court against the dealer to try to establish, as Jonathan mentioned, that this was one of the bad actors, one of the 1%, selling the 57% of the guns used in crimes, not only was that lawsuit not allowed to proceed, he wasn't allowed to do the discovery of the data that would substantiate his claims. I believe that the firearm industry, if it didn't have this unprecedented immunity, they would reform some of their practices that lead to thousands of Americans being killed and injured with guns every year. They would do something about the fact that, as Jonathan pointed out, 1% sell 57% of the guns used in crimes. They would secure their supply chain so that huge numbers of guns aren't diverted into the black market or into private sales where they change hands with no background check. They would install simple safety devices which are proven to prevent accidental shootings. A combination of civil suits and government regulation forced car companies to install safety devices like airbags that we now take for granted. They led to reforms that prevented the marketing of cigarettes to children. The same could be true in the firearm industry. In February, when I introduced the Equal Protection for Victims of Violence, Gun Violence Act, the bill would simply state that notwithstanding Placa, individuals injured by guns who have an actionable claim of negligence or product defect should have the same rights as those injured by any other product. It would also undo a provision included in an appropriations bill that bars plaintiffs in civil actions from accessing the very gun trace data held by ATF that they need to show a pattern of negligence by a gun seller. I was recently invited to appear on a program to speak about this issue along with Veronique Posner, whose 6-year-old son Noah was killed in his classroom at Shady Hook Elementary. Ms. Posner said it best when she said that legal immunity leads to impunity, and that is exactly what has happened. Impunity doesn't end with Placa. It extends into our criminal laws, where we do not have a statute criminalizing the actual act of trafficking weapons or purchasing a gun on behalf of someone who isn't allowed to own a gun. It extends into restrictions Congress has put on the Center for Disease Control, telling them not to study the causes or solutions to gun violence, which kills 30,000 Americans a year. It extends to legislative riders, like the T-Heart restrictions that place strict limits on the ability of the ATF to enforce the law, investigate bad gun dealers, and use gun trace data to stop criminal gun trafficking. To give you a further idea of just how absurd all this can get, a couple years ago, Government Reform Chairman Darrell Issa was investigating a scandal in which ATF agents allowed guns to cross the border into Mexico in the futile hope that they could be tracked back to their final destination, Operation Fast and Furious. Chairman Issa wanted the ATF to track the serial numbers of some weapons recovered in Mexico to see where they were sold. Because of the T-Hart Amendment, rather than ask the ATF itself, Issa had to write to the Attorney General of Mexico, asking him to submit those gun serial numbers to our ATF for a trace. I offered an amendment in the Appropriations Committee that would have created an exception to allow Congress to request trace records for oversight purposes, but the committee voted it down again on a party line vote. That is how absurd this problem is. Since we've introduced the bill, I've been heartened by the response and the public interest. There's a real sense that in Congress that things are changing and the NRA's power is not absolute. Passing the bill and repealing Placa is going to be a very difficult fight for many reasons. The opposition includes not just the NRA and the power and money behind the NRA, that is the gun manufacturers, but also a large and vocal wing of the opposite party from mine that opposes tort claims of almost any kind. It's also going to be a challenge because there are widely divergent views in the country on the nature of guns and gun violence. David touched on this, and let me conclude with a final anecdote. In that race that David mentioned, the 2000 presidential race, David is exactly right. Al Gore won that popular vote, but for a terribly decided Supreme Court case, he also won the electoral vote. But that's probably a discussion for a different panel. But nonetheless, many felt at the time in 2000, and that was the year in which I was first elected to Congress, that the gun issue had cost Al Gore the election. Al Gore lost, for example, his home state of Tennessee. Had he won that state, he would have clearly been the President of the United States. After that election, I was invited to speak on a panel about the impact of the gun issue. In my race in Los Angeles, I was strongly opposed by the NRA. I was challenging an incumbent with the strong backing of the NRA. One of my fellow panelists was a guy named Brad Carson, a wonderful member from Oklahoma, a Rhodes Scholar, very bright guy, fellow Democrat. And we were asked, what was the nature of the gun issue in your respective races, in your respective districts? And I said, well, in my suburban Los Angeles district, when people think about guns, when people talk about the gun issue, they think about drive-by shootings, they think about gang violence, they think about, as I alluded, someone going into a daycare center and shooting a bunch of kids, or a schoolyard in Stockton and shooting a bunch of school kids there. That's what they think about. It's not so much about hunting or self-protection. Well, it got to be my colleague's turn to speak, and he said, well, in Oklahoma, when people think about guns and the gun issue, it's also not so much about sport or hunting or self-protection. It's about Lexington and Concord. It's about Lexington and Concord. And I had to pause for a moment to fully comprehend what he was saying. His district was so different from my own. But in his Oklahoma district, the gun issue was synonymous with what it meant to be an American, with the founding of our country, with the power of people to rise up against an authoritarian regime. And that's what it meant in his district. Now, this was a fellow Democrat, so you can imagine if the diversity of views between two Democrats is that broad, how it is among Democrats and Republicans around the country. And this shows the enormous challenge. But nonetheless, things have changed, I think, and changed quite dramatically with traumas to the country like we saw in Newtown. And we have two very distinct gun problems, in my view. We have the problem of the horrific everyday violence that we see in many of our cities, and we have the problem of the terrible violence to the fabric of the nation itself like we see in Newtown. They require different solutions. And if we're not going to act now, after the horrors that we've seen, I can't imagine when we would. So thank you for inviting me.
The next part of our forum involves cross questions, and I'd actually like to take the prerogative of the moderator to pose this first to Representative Schiff, but then anybody else who wants to respond to it. And I want to pick up on the last thing you said, because I was thinking about that very point. There is, in fact, a strong tradition in the United States of distrust of government power. And George Washington said an armed citizenry can best resist tyranny. I mean, what you talk about in that Democrats' district is widespread, very widespread. It's my view, however, that this particular aspect of the, call it the gun control agenda, this effort to impose economic accountability on the negligent pieces of the industry, which, as everybody pointed out here, you know, if they would only stop supplying 1% of the dealers, it would make a huge difference. It is my belief that if the merits and substance of this argument were clear to the public, those people who, and there are many of them, and frankly, I even have occasionally some empathy with that point of view. Those people who are afraid of potential tyranny and see their weapons as a bulwark against that, I don't think what we're talking about is even inconsistent with that if they understood our arguments. That's why I introduced this forum by saying, in my view, the least inconsistent effort with the Second Amendment. I believe the things that we've been talking about, imposing this economic accountability, is not at all inconsistent with the Second Amendment, or even with Second Amendment values, the kind that you just referred to. And so, but for the fact that those whose primary interest is selling guns, not bearing arms, but selling guns, they have painted this as an outlier, as an ultimately extreme part of the picture. But it really isn't. This, I believe, is as close to the center, if it's understood fairly, as any gun control measure. So I guess my question to you is, frankly, a lot of people say, my God, repealing Placa, that's never going to happen. That's the least possible alternative. I believe with appropriate PR, I suppose, your fight should be a winnable fight.
Well, Dan, of course, I agree with you completely. And for many of the reasons you expressed, you know, as you pointed out early on, the Second Amendment doesn't guarantee the right to manufacture or sell weapons. I would add to that, it certainly doesn't guarantee the right to manufacture and sell negligently. There is no Second Amendment or any amendment right to act negligently in a way that harms others. So there is no constitutional grounding to the opposition. And from that point of view, you're absolutely right. In those communities where people feel that the Second Amendment covers assault weapons and covers grenade launchers and flamethrowers and F-16s, they still should accept the point that there is no constitutional right to act in a negligent fashion, whether you're making cars, guns, tobacco, liquor, whatever. Offsetting that advantage, though, is the difficulty of the fact that this goes right after the financial base of the NRA, which are the gun makers. Right. And it will come to a surprise to no one in this room. The NRA often frames its arguments that are designed to protect the makers of guns, the financial backers of the NRA, in a way that would appeal to the broad membership of the NRA. So they're not going to say, we're doing this to protect the makers, we're doing it to protect the sellers, and by the way, you private sellers, we don't care about you. We didn't include you in Placa because, frankly, you don't pay as much of the freight as the makers and the sellers. They're not going to package it that way. The way they will package it, the way they have packaged it, is saying that these lawsuits that my colleagues have talked about to try to end these practices would put the gun industry out of business and therefore preclude law-abiding citizens from having weapons they can buy. That was part of their argument, even though none of this litigation up till that point had been successful, and even though a lot of this litigation, like the NAACP lawsuit, for example, wasn't seeking damages, it was seeking injunctive relief, asking only that the negligent practices be enjoined. So I think you're absolutely right. Philosophically, it should be a much easier sell. I think if you ask the American people, it would be very popular with the American people. But it goes directly after the financial might of the industry, and that's where we'll have our challenge.
I'd just like to add, I wish the rational discussion of why this law should be repealed could prevail, and I hope very much it does. And I wish you, Adam, nothing but the best of luck, and my boss is certainly right behind you in urging this. But I think we do need to recognize the reality that nirvana may not happen, or may not happen soon. And I think, therefore, the importance of discussing how, under existing law, we can bring lawsuits that will succeed, even notwithstanding the existing impediments, is very important. And that's why there are laws on the books, such as laws against straw sales and the like, that dealers are violating. That was the basis of our lawsuit against the dealers. And I think if we can better publicize who the bad dealers are and get the information out there, and then say to the manufacturers, for crying out loud, we told you who the bad dealers were. This is not a secret. At the very least, we can sue the bad dealers, because they're violating federal law. And maybe we can get the word out enough so that we say that the manufacturers should have known whom the bad dealers were. And I think we have to continue, both as governments that have the wherewithal to bring these civil suits, to continue to bring them. And when, unfortunately, we have the Newtown-type situations where we then have plaintiffs who are the unfortunate victims, we have to do everything possible to support them in their lawsuits. But I think lawsuits such as the City of New York brought, and I would hope other jurisdictions would bring, could really make a difference.
Michael, if I could just add on to that and actually pose a question to you or Jonathan, and I think you're absolutely right. We don't want to wait in the hope that we get this passed in Congress when there are things we can do now. There are a number of narrow exceptions, and they've been interpreted by the courts far more narrowly than I think any of us think is appropriate. There are some narrow exceptions to PLCAA, and some of them depend on the predicate or underlying state law. And I wanted to ask you both, have we had any success with states enacting laws that would neatly fit as predicates so that we can squeeze into one of the exceptions in PLCAA?
Well, I can really only talk knowledge about New York. And in New York, the ground on which we lost our dealer's suit, manufacturer suit, was basically that we couldn't point to a specific New York state law that made negligent sale of guns illegal. And it's very simple to say that you could amend New York state law, nuisance law, for example, to say including the negligent sale of guns. That has not gotten traction. I think it is an issue that should be focused on. I'm not familiar with what has been done in other states.
Well, there is a lot of interest, actually, since Sandy Hook in doing exactly that. And I've been talking to a number of state legislators who are in the midst of drafting legislation which would actually resemble, David, your legislation, which, where you have a code of conduct, responsible behavior, and if you violate that, then you have violated a state law, and then even under PLCAA, you could be held liable for the consequences. And so I think in the coming weeks, in fact, there will be legislation offered that does that. There was a bill, a more limited bill, that did that in Colorado for assault weapons. It did not pass, but I do think you'll see some success in other states.
Just out of curiosity, would PLCAA have to require that the gun dealer be violating a law in the jurisdiction in which the gun was sold? And in other words, that would be maybe the most natural reading of it. Not the best reading for our purpose.
That would be an argument.
But, yeah, right.
And you certainly, so it's possible that would have limited effect.
Yeah, but
it
worth
might,
trying
but not
nonetheless.
necessarily. not necessarily if it had effects inside of the state. There's a strong argument that it should be. under
Judge
jurisdiction.
Weinstein would rule that would.
There you go. And Judge Cardozo.
Well, it's funny because Congressman Schiff, that you raised that question, because I was just raising that question with Jonathan before you came in. I mean, I think that we have to explore all of these strategies, as I tried to mention in my remarks. One is I think your legislation is crucial, but I think we need to look at the statute and the court cases, and I agree that some of the legal interpretations of the Placa statute are not very persuasive to me, but still we need to look at the various kinds of ways that we can either rewrite statutes, whether it's in just adding the language such as including. That's a very critical thing. We need to look at all the possible exceptions and see how we can fit into them. But I also think litigation is important. We still have only 2 circuit courts that have ruled in the way that I don't agree with on what the term applicable means. And so therefore, there's still the possibility in all the other circuits to allow lawsuits to go forward. And who's going to bring those cases? I mean, that's the kind of thing that has to be encouraged. So it's changing the predicate statutes, it's litigating in the other places, and it's doing follow-up litigation. I mean, Michael, does the city have some new kind of weapon, so to speak, under its belt? Does it have some ideas about where it's going to go next?
Well, I think at the moment we're focusing, the mayor is focusing on his legislative efforts, but I think it'd be inappropriate for me to comment what else we might be doing.
Well, and focusing on political efforts, right? Which I do want to return just for a second to the issues that Dan and the Congressman raised about the kind of politics of it, and it's a tough one to talk about because it's, there's some nuance here. The NRA is strong, no question, and I want to talk from him about why exactly they're strong. It's not that they really have numbers on their side. I mean, even on assault weapons ban, routinely polls, I don't know what it is now, 70s? I mean, it was, when it passed in 94, it was polling in the 70s. Even in districts like Brad Sherman's district, I'm going to bet. I don't know for sure, but I'm going to bet. But what made the NRA so tough in those districts was the intensity of the feeling of the NRA members, right? And that's poli-sci 101, I guess. Intensity will trump numbers, and especially if it's not intensity of 3 people, intensity of a whole bunch. Tom Foley, who was the Speaker of the House in the late 80s and early 90s, had all spiel. He would tell new members about, he said, what makes the NRA so tough is they will send, if there's a gun control bill going to come to the floor of the House, they will send a postcard to everyone in your district, and it will say, the liberals, maybe the New York liberals, but the liberals are trying to take away your gun. Put this card down, go to the phone, dial 202-225, whatever it is, and call your House member and tell them. And the member will put the down, they'll go over to the phone, and they'll pick it up. And I think that's what makes them, I think, formidable, is the intensity of it. But the reason I say that is it means there's a challenge on the other side, and this is what the Brady organization has been doing for many years, is to try and match that intensity up to a point. It's never going to be, but to some extent on the other side, and that takes money, period. I mean, that's where the gun industry money comes in. It's not even in the contributions, it's in mobilizing that latent network out there. And I think that's why one of the most useful things important things that Mayor Bloomberg has done as a public figure here really is to put some funding muscle behind the gun control effort.
Just briefly, we at the Brady Center are continuing to bring lawsuits against the gun industry. We have cases around the country, Alaska, Kansas, Wisconsin, Illinois, many other, New York,